Alrighty, we are back. Quiet on the set. Quiet on the set. We're waiting on our guest. One of our guests to get back in here. Tyler, just peek your head out there, see if he's okay. We're back. Planet Green Trees and
Shiler,
continuing on.
Shiler, close that door.
Do you even know Shiler,
Come on.
David? This is
the
normal
door, Shiler.
behavior. You know.
But he's an extra worked up right now.
We were going to do some text talk, but our text talker stepped out. See if he's back. Tyler, one more peek. See if he's there.
Why don't we talk about this?
Who are we peeking for?
Immunity.
Ken.
Federal
Okay.
immunity.
Fine, let's get right into it. All right, we're going to do that, and then with
Yeah,
Amanda.
let's talk about federal immunity.
All right, so this,
Yeah, Shiler.
It's an interesting issue.
Yeah.
right, so,
We have an expert here.
Why do they have federal immunity?
no, here's the thing. People ask the question, you know, my keys got thrown out, and not a lot of people say this, but around here we do. My keys got, where are you going?
Oh, come on.
You offended? Oh, what happened? You left for, okay.
David was teasing him.
I was just trying to get him.
Charlotte,
to
get in here. What is
engage.
wrong with him? We
I
want
was
to talk
trying
about the...
engage
Back
him.
in here.
All right, so the federal court, and this is an issue that comes up quite a bit, this concept of governmental immunity. Can you sue government officials? Standard response is no, because of the concept of governmental immunity. Some government officials have absolute immunity, and depending on their rank and file, and the further you get down from the higher ranking and file, there is a lesser threshold to overcome the immunity, but oftentimes in criminal cases, when someone's found not guilty, for example, they may say, can I sue the government now? Found not guilty. And the answer is usually no, because the prosecutor puts their case on and they have absolute immunity from lawsuits
Well,
in their
it's not
government
absolute.
function.
Why are
It
you
is
saying
for
absolute?
prosecutors.
It's not
absent-
absolute.
well-
not if they engage in misconduct.
I don't know if misconduct does it. If they step into an arena that is not, in limited instances, but if they step into an area outside of their function as a prosecutor, then they have a different role. There's a case out of Oakland County where the prosecutor made slanderous statements in the press about someone. He does not have immunity in that particular instance. Police officers have to be grossly negligent or some other breach of duty that is reckless or grossly negligent in order to overcome this. But the point of the story that we were reading here, we've lost the fun of Shiler, is that in a matter where it was known that the police officers stole over $225,000, the Ninth Circuit of Appeals this month unanimously ruled that the Fresno police officer accused of this theft were entitled to qualified immunity and can't be sued. Thanks to this doctrine, police officers, sheriff deputies, and other public functionaries are shielded from civil rights lawsuits. And we're going to talk about that for a second. If that's an answer, Shiler, if he's out. He's not allowed back in the room. I told you he's just a distraction. It's the only thing he can. In any event, is this a problem? I mean, when you know, and if it's a you get your right to, we live in a country, you get your right to a trial. You're exonerated, and exonerated is what you get. There's no money you get back. It's you get the right to a trial. In some instances, you can proceed against the government if there's behavior or circumstances that are clear violations of constitutional rights, and there's damages that result from it. Obviously, talk about punishments that are, prison or whatnot for, some police officer gross negligence or prosecutor, bearing evidence, and but it's an interesting phenomenon because the argument for this immunity is that the government wouldn't be able to function. They would be afraid of getting sued all the time, and they would then not be able to perform their duties. And we have to insulate them to a certain degree so they could function in this capacity. I mean, there's the argument, which is that let's say a judge in a case makes a terrible ruling that results in something being heard by the jury that shouldn't have been, results in a conviction, sentence the person to 3 years in prison, 3 to 15 years in prison or something, and the judge is overruled, and the guy spent 3 years, or she spent 3 years in prison. Can you sue the judge for the stupid error? Well, absent some intention to do that, specifically if it's just a neglect or or mistake, that's not going to carry the day. And
But this case is fucked. They,
it is.
The question was whether the cops literally stole it, acting outside of their duties as police officers, and didn't claim it, and took the money. Like, they performed a search warrant, found all this money, and
Reported some of it.
reported 50,000 when there was like 300,000, essentially.
Sounds
And like
right.
how they're not acting in a government capacity. That's usually what the line is. Is what are they performing their job duties, or are they outside the scope of their job duties? And the court found that stealing the money was inside the scope of their job duties, essentially.
That's probably about right.
See, the
And
way,
therefore they're they can't get in trouble for it.
Yeah.
I mean, it just seems insane. It seems insane.
What does Shiler think about
here, let me
that?
tell you this. This is the way it's been read. The Supreme Court on this issue has said they've made an exception to this qualified immunity for cases where the violation was so obvious that a general constitutional rule already identified in the decisional law may apply to the obvious clarity to the specific conduct in question, even though the very action in question has previously been held unlawful. That's so what they're saying is it's got to be the actor who's being called in for these, the act through the actor's eyes, that they should know that the violation was so clearly obvious and understood general constitutional rules that have already been identified in decisions, etc. Now, in this case that we're speaking of, where the Ninth Circuit ruled regarding these Fresno officers, specifically, the case is called Jessup versus Fresno, stating that it wouldn't be clear to a reasonable officer that stealing $225,000 would violate the Constitution they've sworn to uphold.
Oh, stop it. Stop it.
No. And to rub salt in the wound, the court declined to decide whether or not the alleged stealing by the Fresno officers actually violated the rights of the people to whom were stolen from. As a result, if cops are again accused of stealing seized property, they most likely would be shielded by qualified immunity, since it still wouldn't be clearly established that their actions are unconstitutional or that they took a oath to uphold it. It's not a great case. I would say, Charlotte, that's maybe why you sent it to me 45 times, but he's not here to defend
That's
himself.
why he walked out.
Whatever.
Because he knew it wasn't a great case. He didn't
I
want
mean,
But that's an answer to
it's
some.
unbelievable.
Yeah, but
it's an unbelievable ruling. It feels like an Onion
Where
article.
did this happen? I just came in.
Fresno.
Fresno, California.
I mean-
They robbed people, and they got caught, and they say that that's not. They didn't know that robbing
That's no
people
big
was
deal.
unconstitutional.
No, that's not. No.
It's insane.
It's also the U.S. Ninth Circuit Court, which is a very liberal court.
Yeah.
I would
Usually,
think they would go
nothing
the
that
other way
happens in
around.
the Ninth Circuit matters because they're so liberal that the other courts don't really listen to them. Like, it doesn't. Those decisions don't hold a lot of weight around here.
Yeah.
But that's like a conservative, weird
yeah. It's like a.
decision.
Is it? I mean, I don't know. It's an interesting dynamic. I think
Well,
that.
how could stealing not be obvious and
No,
clear
no, no, no,
that
no,
it
no.
was not
Is it-
upholding the Constitution?
Well, listen. The only way you can get here. I mean, somewhere in this opinion, I read the actual opinion where they discussed, the concept that pretty much every single civilized country understands that stealing is, not tolerated. You know what I'm saying? Like, it's a general principle. Yet,
In the opinion, they say this?
yeah, they refer to it.
What about?
But then
these-
they excuse the police officers from thinking that it's a crime. But the point I want to make is, as outrageous as that sounds, this is in a common theme that you find throughout the United States jurisprudence, Michigan jurisprudence. It's the, tie go to the police officers. The questioning of the.
This isn't a tie.
I'm saying the war on drugs has been
It's
won
like beef.
by the police officers testifying that they saw this, that, the other, and even if their testimony is impeached and their integrity is impeached, the courts have utilized their discretion and found it in favor, and the courts of higher level have all enforced that, giving this discretion to the observer of the facts, trial courts, and and things like this, giving them the deference. I mean, how do any of these cop shooting cases end up not guilty? I mean, how do they all get, if they're ever? I mean, they're getting convicted, but if any of them, when you see think of those cases of what that there's been some. It's because the instructions that are read, the rule of law that's been built into associated with their functioning. They are immune from what would otherwise be illegal in a lot of ways. Last week, for a moment, I think we were talking about how is it that their profession rewards them for their ability to trick and deceive and lie, even in doing so they may be a better performer in their task. How do you invite? I'm saying for getting confessions or talking to people and persuading them to do things or whatever, and that's all legal, allowed, and but.
Yeah, but not when they're stealing money from.
Well, I'm saying to you, it's the
people
culture.
off books.
The culture that we're talking about
Like do you think
defines the ability to lie as being a.
yeah, but here's the thing. They
Not all-
lied in their police report about how much money they took because they knew they were not at all acting
Allowed
as
to do
police
that.
officers
Sure.
when they were
I
stealing
got it's
that
a
money.
terrible opinion.
So
What do you
it's
want me to say?
It's so obvious and clear that they knew.
Of course they did.
Yeah, otherwise they would have
knew
lived
It's like,
above.
was, is this your money?
I mean, yeah, it's just like how is it? It's baffling. It
My
really
concern is how much, because this is a U.S. Ninth Circuit Court, does this carry precedence throughout the United States?
No,
now,
it's
or
something
is
to be
it
relied
just
upon.
regional?
Yeah, I mean, they'll get some. If another issue comes up, some
Somebody can
use the the discretion of the next court that's challenged with this issue of whether
Right.
they should dismiss it or let it get to the jury. Can, if they wanted to, rely upon it. This is what you call jurisprudence. Michigan doesn't have this, but in the federal court system, you've got these different circuits.
Yes.
This issue goes here. This issue goes here. And if the Ninth Circuit, says this is immunity, and another circuit says it's not immunity, then the Supreme Court takes it. Then you make. See what I'm saying?
I see.
Michigan is one court of justice. So once the Court of Appeals issues an opinion,
Okay.
they don't want to hear from anybody else. Do something. There's no
I got you.
contrary. That judge, that ruling, those three, that day, good day, bad day. You know what I'm saying? There's no.
Right,
that's
right,
not
no.
jurisprudence. It's
Right.
it's a phenomenon that.
But at this
Did you ever?
level,
Do you know that?
What?
Do you know what I'm saying? Like the concept of, in federal court you have two different circuits that.
Yeah, and then they
are-
can have difference of opinions and.
And,
something
right, and the
settle it.
judge can then rely on
But,
one
I
or
mean,
the other.
It does kind of happen in Michigan.
Never.
What about Carruthers? And then what's the
Carruthers is
Neil,
the-
no
okay.
the wet marijuana cases. Neil's case was Mansour.
Okay.
And then there's a second case.
Do you know why?
that
Do you know
says
why that is
they
not the-
interpreted what wet marijuana is?
Right.
Multiple.
Do you know why?
different Court of
Okay.
Appeals.
Do you know what you're saying? Okay. The case, the depth of that case law, if you pull it back, is that there's no jurisprudence that we're going to decide which is the right answer. They said first out wins. Remember? First out wins. In Carruthers, even though the case has been overruled and they amended it, what remains of it is this thing that they created, which is this, possession of not usable marijuana is illegal. Remember that? Because that was what Carruthers said.
Yeah.
Okay. So so despite Manuel, right? The Mansour case and what's his face said no. Carruthers came out first. That's what wins. It wasn't based on jurisprudence. It was first out wins. That's Michigan law. That's how we do it. There's no.
Yeah, but still, there's another Court of Appeals case, Mansour, that says he was immune with wet marijuana, right? So there's two different Court of Appeals
No,
cases.
Mansour says-
Mansour is new. Well, Mansour is newer
said
than Manuel, but it's over. Somehow the Court of Appeals.
Mansour
overruled themselves.
overruled.
Manuel, but it's a Court of Appeals and Court of Appeals.
Right,
Two
but they
different
said in their
panels can't
opinion. Right, I get
overrule each
that.
other.
I get that. But then we have the.
So is this split on case law?
No,
We
there
do have a
isn't. No, there
split.
isn't because the other case that went to the Michigan Supreme Court, name escapes me. It's Mary Chardier's case. We're in the weeds now, David. Good job.
I'm sorry.
But let's just finish that because the
We're talking about crazy court.
what's the
court
case?
opinions.
No. The Supreme Court of Michigan has ruled on this in remanding Mary Chardier's case
Yeah, I agree.
to enter
but that
a-
was before Mansour.
to write an.
That was before Mansour. That
Well,
happened.
by default, Mansour is overruled.
I agree. Mansour's stupid. So is
It's
this
not
case.
stupid, it's
This
overruled.
is one of the dumbest cases I've ever seen.
Okay. All
So
right.
What if,
Mansour
what
is
if
one of the
another
dumbest cases I've
circuit
ever
court
seen.
doesn't? What if the other circuit courts don't do anything with this? Is this a precedent or what?
It's a precedent in that circuit.
That circuit.
That's
So there's.
But
not-
federal
that's a-
judges
that
will look
affects
to
a
other
lot of-
circuits
Right.
when they want to figure out what's going on. They may go against it, and then that will be some developing of some jurisprudence of that circuit and circuits around there.
But I mean, the point is, right now in the Ninth Circuit, if you want to sue a cop in federal court for
Yeah.
robbing you,
yeah.
Listen,
probably
an
gonna
important
lose.
twist on this, which is not recognized in the story. What's so funny?
I was just saying you're gonna lose. That's all.
But here's the thing: the lawsuit is based upon this theft, and that may not be a civil rights violation in a technical legal way. You don't have there's no constitutional right not to be stolen from
I think there is.
by the police,
There's no constitution to keep
I
your
think there
own
is.
property.
I think there is.
not as a recognized right, or that they would see it as a constitutional violation.
They were depriving them of the
I am not
property.
defending them.
We're not asking.
I am not defending them. I am suggesting if there is a reason how or why they could go here. Clearly identified, First Amendment, Second Amendment, Third Amendment, Fourth Amendment violations, Fifth Amendment that result in damages
All
are
these
things
amendments.
that would not be, that they've already identified as officers. They're trained. They're Miranda. Fourth Amendment. Shit. But here, I don't know. I mean, I'm not. I'm just giving you the nonsensical perceived legal analysis here. When the civil rights case 1983 are based upon clearly identified civil rights violations, that is not what's alleged here. You know what I mean? Like you don't. When someone robs you, it does not invoke.
The right.
It,
The
it
Fourth
does
Amendment.
when they
Fourth
are an
Amendment.
agent
the
of
right
the
People
government.
to be secure in their persons, houses, papers, and effects. Right.
Well, the illegal
Fourth
seizure.
Amendment?
Illegal.
Yeah, illegal.
When a
seizure
government agent robs
for
you,
unreasonable
it
searches
is
and seizures.
it
That's
is
an
a
unreasonable
violation.
Seizure, right?
a constitutional
When they
violation.
took it home with them.
Have been reasonable.
Yeah, I mean, when they took it home with them, the government. didn't
Yeah,
keep
they
it,
put it
was
in the
like,
trunk, man.
Before due process of laws happened.
Yeah.
Like they stole it.
I'm not
without due
defending
process of
the case,
law. I think it's
please.
a due process violation.
I don't know,
also,
man.
clearly.
I'm with. Listen, talk to the judge. We brought this up to show the outrage and
I'm
some
just
of the
saying,
problems.
It is clearly unconstitutional. What the fuck?
So it's okay for the cops to go on a spending spree right now with that cash?
Oh yeah, they're partying right
Yeah,
now.
I
That's
want all your
essentially
money,
what they're
Dewey.
saying.
Michael
Can I-
says it's okay, so give me all your
Can I-
cash, okay?
Can I make another point, which
Now.
has been a trend in the jurisprudence of police officers' issues, is that their mistakenness, when they make a mistake, is in the jurisprudence of Michigan forgiven and accepted. There's
reasonable mistake.
okay, but
Which is
it is
whatever,
there. It's
whatever the fuck the judge
which
says
is right.
reasonable, but-
The question is: it reasonable that they made a mistake, such as not knowing the law while they pulled you
Such
over?
as robbing these people of $220
I'm not saying here. I'm saying in the,
But in general, like they can, if they're just like, I just fucked up. I gotta be honest. I
fucked up.
honestly thought they did that, but I was wrong. Like if they
For
just look
example-
at the video and say I was wrong, I made it, but it was an honest, reasonable mistake.
there's a really funny.
Totally sorry.
You know, we were arguing that case about probable cause before the Court of Appeals on smell, and the officer in that case who had another case dismissed at the trial level, and the Court of Appeals reversed it and sent it back. So as it came up, you have an officer that's already had a case dismissed for the reasons that are articulated within this opinion, and they bring it up, and she's armed with this. She's explaining and answering the questions. Well, it was a reasonable mistake. And it empowered her to virtually do anything, because your answer is I didn't know, or I was mistaken. I didn't know that, because it's on knowledge. It's on their training. They mistakenly didn't know that the case at issue is the believing that someone had a taillight out. But the ordinance that governs this was not that, like no cars don't have taillights. Like one bulb goes out, there's 5 others. You know what I mean? And it's like, got to have a light that can illuminate for 500 feet or something like that. You got to more than that with the remaining bulbs. And the idea that they're pulling more for one taillight is absurd. It doesn't comply. But it's a reasonable mistake, they said. So whatever came out of that, they pulled the car over. Oh, it smells like weed. Get out of the car. Oh, you got a, dead body in here or whatever. But
Oh, you got $200-some thousand, and
cash, right? We're
it's
taking the
reasonable
cash,
that
right?
it's in my trunk now. So
Right.
yeah.
But the point is that those kind of, I pulled you over. They looked like they didn't have a tag on their car. When I got up there, I could see on their window that it was there, and they had a whatever.
So now I get $100,000.
I'm just saying.
200 and-
no. Listen. The point I'm making is
225
The government.
grand.
Here's the point. The point is that the government can't just randomly pull you over. They have to have a reason. They have to have a basis of a traffic
it's a
stop.
good reason.
And when they pull you over, and the reason for the traffic stop is not valid,
It's bullshit.
it's a reasonable mistake because they don't know the law. That's what I'm saying to you. So, with that being said, and that issue, and your freedoms being chipped away with out on the road,
On the road
and
again.
my point of being how the law enforcement has gotten away with a lot, and a lot of their behavior has been codified by the courts.
Yeah.
Okay, next topic.
Next topic.
Florida Congress. Well, hold on. Let's get Ken here real quick, and we will.
Speaking of the government stealing money from people.
Yes.
That's great. All right, maybe I'm going to be flogged here in a minute. Get the
You're
whips
on.
out. I'm done.
You're on.
Ken Kayo, accountant,
Yes, Mike.
certified accountant, CPA. We're not going to get into everything we talk. First, Ken explained. Ken, I just want to mention, has been working with our law firm. He's our go-to accountant for a lot of things dealing with the business and function of businesses within the cannabis industry. There's this 280E, which if you're participating in a regulated system, you're well aware of, you should be aware of, and some of the minimum requirements that you have, oversight and auditing, and Ken is our go-to guy on that, and he even offers these really special CFO services for those businesses and
Yeah, we-
minimizes the liability of the business. But
Yeah.
I've said too much. Maybe Ken, please
No, I
tell
just
us
wanna
about your.
say, Yeah, I'm a CPA. I've been a CPA for about 35 years. I've been a CFO for a couple of startup companies, and then I decided to do a redo with an aquaponic farm in Livonia with a group, and then we morphed that into a greenhouse. And during that time, I had a lot of experience on the CFO and CPA side, and now on the farming side, I have farming clients. And I kind of fell into the cannabis arena. And what we do is we offer accounting, tax, and CFO services to the cannabis industry, all license types. And what we really do is make sure that they're compliant with their records, their taxes. As Mike mentioned, there is a 280E issue, which if you are in Schedule 1 or 2 drugs, if you want to call it, that is where the 280E is, and that's where cannabis is right now. So we help firms become compliant, and not only become compliant, but stay compliant. And I have my own team of people, both IT and bookkeeping, payroll, etc. So it's a team that makes sure that the people who have MFLA and with the new adult use coming on board, we help them with that as well. So I've been working with Mike because he has some clients that are interested in those kind of services. So that's how we kind of work together.
That's right. And we're going to do some more. Ken's going to come back and talk tax more, and we're looking forward to that. But we have so many people here, and there's exciting news this past week. Amanda, we don't want to not give that the full attention. And as I say that, let's talk about something else right now. Just kidding. Do you want to
Topic
do the next
two.
Do you want to do the next
Topic
topic
two.
Okay, we still got enough time to give Amanda her full time?
Yeah.
Okay, fine.
Of course we do.
Florida congressman wants to downgrade controlled substance scheduling for marijuana.
Yeah. Schedule 1 to Schedule 3.
All right, let's go around the room. Who's in favor of that? Jim, you in favor of a downgrade to 3 from 1?
Not really.
Deb?
I'm not sure yet.
Okay. Jeanette? You take a schedule
What's the
3.
question, right?
Florida downgrades marijuana scheduling from a 1 to a 3. Do you agree?
I mean, I think they should just take it off totally.
Yep.
Okay, I like that.
Yeah, I agree with
That's
that.
it. That's probably, okay, Amanda?
That's a good
I do
answer.
not agree. I think they should just
Do away.
do away with it.
Ken, you want to opine?
Yeah, I agree. I really don't see any benefit. Why should he be scheduled?
Any,
Because-
John? Nikki?
I disagree. They should throw it away, and it should be totally.
Yeah. Okay, yeah, I mean, it's not
Bring
a tough,
Shiler and he'll
it's not a tough
disagree.
crowd. That's interesting.
But if the only thing that is possible is that it moves from 1 to 3, 3 at least alleviate some of the consequences.
That's a good. I
Three
think.
will alleviate the 280E.
That's a Jeff
Okay.
Irwin
That's why
argument.
they're going for 3.
However,
Okay.
does
Well,
that
Jay.
not just take out? First of all, I mean, if it's Schedule 3, then it is a
It's a federally
controlled
Controlled
substance.
substance.
That's right.
Regulated.
So the people that are going to be doing this are the people that make controlled substances.
Yes.
The problem
you are gonna
is-
lose out
here's
to-
the problem when you deregulate is the pharmaceutical companies now have free reign. Because
Yep.
now they can get in there and...
If you wait, if you
Yeah.
unschedule it, you're saying?
No, even if it's a 4 or 5.
Well, that's what I'm saying.
Yeah,
they
as
have
long
the,
as it's
they
on
have the
the-
advan-
The pharma companies can now do their
o-
research and they can get
the-
in there and they can
And we
just...
still can't have it.
by it being a 1, it keeps pharma out.
Yes.
It
It
does
lets-
keep the pharmaceuticals
Okay,
out.
okay. Do you understand what I'm saying? So
Yes.
moving to a 3 has a negative impact.
The only reason
it
that
does
the
for that aspect. That's
the, on,
correct.
the only reason that the businesses that are around that
Yes.
are in their current
Right.
state and operating is because it's federally Schedule 1.
If somebody was in their basement making well, I guess it's not, or making like some drug that oxycodone, they're not going to kick in your door, shoot your dog, and take your guitar collection. They're going to like kidnap you, take you to. It'll be a pharmaceutical company. They're in for it to take it to an island and sprinkle dust on you, and you're never heard from again, and nobody cares. You know what I mean?
Right.
So it's like that you're dealing with a completely different functionality.
And
Of
it's
who's going to be
coming.
fighting for
It's-
the protection of this?
Here's the dilemma. Hemp is now off schedule.
Boom.
the entire plant.
Boom.
So now you got the
Yes.
cannabis plant that is a relative of it. So now
Well,
you got
no,
you got an issue.
no, they're not relatives.
Well, I mean, they're the same.
There,
same,
it is.
Same strain.
This is the
But
issue.
it's 0.3% lower is his hemp right now. But I'm just saying that if
The
you wanna
federal
get
rule is it
technical-
right? I know the federal rule, just for clarity, defaults to the cannabis sativa L plant,
Mm-hmm.
which was previously known as marijuana and controlled substance Schedule 1,
Right.
is now not that. It's off the list, and
Right.
only those parts of the plant that are greater than 0.3%
Right.
of THC are marijuana. So by default, so I agree. That's even makes it, and that's an even better argument. And
It's
and-
muddying the whole thing.
well, the ability of any of these labs to distinguish is a question for another day. But
Yeah, that's a whole that can be a whole so whole
The-
2 hours.
no, I know, and
And that's
um,
the USDA's problem right now is how do they test this? And
Right.
where do you take the tests at? Do you take it in the middle of the field, at the corners?
no, I know.
There's all kinds.
Michigan's created some rules for that, and we should get into that more.
Yeah, they
And
have. but
I'm good.
it's-
I don't know that.
The USDA could. Well, anyway, that's some of the discussion is
Sure.
going on. Is
Clearly, from the tax perspective, if it's not a controlled substance, there's
it's-
no issues,
hemp
right?
is,
Yeah.
You can apply farm accounting to it.
Sure.
That's
Tomatoes.
the way it's going to be. yeah.
Tomatoes.
Right.
It also gives me a chance to segue for a minute to give an update on the John Sinclair case, which we've had a difficult time getting a judge to spend any time when he considered even give us oral arguments. It was summarily dismissed out of the Court of Claims, which we anticipated.
Yes.
We then filed it with the Court of Appeals, and we were granted some oral arguments. We're going to get heard on that. But the opposing party, as we all know, is the Attorney General's office. They seem to be
What is their problem?
fighting hard on this.
Any idea?
You know, the basic theme of the argument is that, they're saying there's no harm. There's no immediate harm that would warrant this action that we filed. There's no, there's no duty, and there's no. And our position is meritless. Essentially, our position is that you can't, it contravenes logic. If I'm not even a recreational, but the idea that the individuals that are involved with the MMFLA themselves are not doctors and they're not prescribing medication. People are obtaining this substance from a regulated system similar to alcohol. You can call it whatever you want, but it's not within a tight regulated, pharmaceutical, government approved, FDA, DEA, saying, yeah, it's okay, you're good to go. That's not this. This is the opposite. This is not pharmacies. It's not, it's state regulating people who, have pass a background check and have funds. That's not a bar that we identify the concepts of controlled substances. And then, in what planet do we have a Schedule 1 drug at the state level? It's not federal level, but I'm not talking federal. But at the state level, Schedule 1 drug, that is the same government that wrote the laws surrounding that and maintaining it, have adopted that same Schedule 1 drug can be used recreationally and are going to give licenses to sell it to adults to do that. Let me explain what I mean here. The idea here is that if you understand what Schedule 1 means, is that it's dangerous, there's no medical value, and it's highly addictive.
Yep.
Okay? That means that it's the worst of the worst. It's contraband per se. It's illegal to possess. That's where it stands. It's Schedule 2, according to our public health code, if it's for medical purposes. But it is being used by adults recreationally. The idea that some controlled substance on the controlled substance list could be received at a store, a certain amount that you can use recreationally, is laughable. Or even under the MMFLA, and this is at some point the MMFLA in its controlled system that they want, controlled substance idea that this is going on, they were allowing caregivers and still allow caregivers who are growing cannabis in their basement, which I'm in favor of this, but conceptually taking it up to and provide it into this regulated system. The analogy would be if the pharmacy is short on oxycodone and people are going in their basement, bringing it up to the pharmacy because they needed some. You know what I mean? That is not conceptually a controlled substance system that we're operating in, and it's laughable that we're operating within this. And and people are utilizing it for recreational purposes. I don't think there's. I don't know how we. It's like alcohol, right? We pass a law. It's like alcohol. It should be regulated like alcohol. It's not. Alcohol is not on the controlled substances.
In some states, when the legalization passed, there was an automatic change, like in the state's controlled substances list, to reflect the new change in law that contradicts what it says. Same thing here. It should be. I mean, if it requires an extra step of legislation, then that should be an attention given to that, and it should be changed, as soon as possible. There's been a new law that contradicts it. It should be just a matter of course.
To whatever extent you want to, like in the next topic we're going to discuss. Good segue. These are great segue. But there's criticism on the wire of MRTMA, ramblings, misinterpretations out there. Okay, and
Concerning decriminalizing
the interpretation of what the law means, and that and I'll get to that in a second. But what I'm getting at is that whatever MRTMA provided for us, there are still people who are being prosecuted for driving with THC in their system. There are people who are, if involved in an accident, are being charged with crimes as if it is a Schedule 1. The reason why the penalties associated with that area of the law, driving and control, either having it in your system as a zero tolerance, or having your system and suggesting that certain amounts make one impaired, is because it remains a Schedule 1. You see what I'm saying? There's a crime that if you are in an accident, you have Schedule 1 in your system, there's a severe penalty because they intend to punish you as if you've got Schedule 1 in your system. And even though the punishments for the possession of marijuana is a misdemeanor, and the possession of all other Schedule 1 drugs is felonies, and that's kind of been the way here in Michigan, the treatment of marijuana in one's system for driving has not been minimized or punished any less like it is for and the problem is that it remains a Schedule 1. The same could be said for CPS issues. This is an ongoing thing too. If it was not scheduled,
I don't buy that personally. Alcohol is not scheduled either, and it's a huge problem.
For children?
Yeah, absolutely.
Do you think children using it, they're taking it away?
No, I'm
No, but
saying
CPS
that
can interpret a situation to be an endangerment to the
Yeah.
children, and then if it's alcohol-based, it's alcohol-based.
it doesn't matter what it is. It's their interpretation is that marijuana impairs you to the point you can't take care of your children, and they think the same thing about people that use alcohol heavily.
Well, I think the premise of the training. Look at. There's a lot of that's a heavy topic. I don't know if I want to start generalizing there, but I can tell you about specific scenarios that I think is what drives it. And the training and the discretion that's given to a lot of these investigators is there's no discerning it. I know that they recognize the legal. All right, but so let's talk about what I was referring to, because as I mentioned, the Attorney General's office is contesting our fight and battle over the John Sinclair case, where we're asking the court.
Did you ask her why?
I'm not. She's not handling the case. She herself, the general herself, may not. I'm assuming. I don't know. I'm not gonna. She's got.
Well, what about her deputy AG that? You guys
call her. Did you vote for her? You call her.
I did vote for her. I may have given her some money too.
All right. So.
A penny or two.
So our Attorney General created this. So this is what I was want to talk about. Let's see the. Okay. Attorney General press announcement said she forms a marijuana legal work group, as opposed to a marijuana illegal work group.
Right.
And Attorney General Nessel announced, this is back in May, creation of a marijuana legal work group to be housed at the Department of Attorney General. The work group, chaired by the Nessel, will meet on a regular basis, review, analyze, discuss, and opine on laws and regulations concerning the recreational, medicinal use of marijuana in the state of Michigan. Comprised of a diverse group of persons with different backgrounds, experiences, including some stakeholders in marijuana law regulation.
Ken Stucker.
The group will make recommendations to the state legislature, law enforcement, the judiciary, prosecutors, defense attorneys, etc. We are working hard now to avoid the years of uncertainty, lawsuits, and appeals that followed the enactment of the MMA in 2008, Nessel said. With new laws and regulations on the books, particularly concerning recreational marijuana, I am confident this diverse group collectively has the knowledge, experience, and thus credibility to make recommendations that will be accepted and implemented by all involved. The names of people are what?
I was talking to myself.
Really? It sounded like, okay. I would not have thought that was going on. Let's name some. Let's say Bob Beldori, we know, is a lawyer for Lansing. Paul Bernier, city attorney in Livonia. Andrew Brisboe.
Livonia loves marijuana.
Well, I'm going to mention him in a second because he's a spokesperson for this agency.
Yeah.
He's a friend of mine. I like him. We don't agree on things, but he's a
I don't think
nice
you like
man.
some of the other people on this
Andrew Brisboe is the executive director of the Marijuana Regulatory Agency.
Oh.
Margaret Bruner. Robin Frankel, assistant attorney general. She's a longtime criminal defense lawyer and solid appellate lawyer. I know she recently joined the AGs. James Gidding. Daniel Groh is a member of the marijuana law section. Chris Hawkins, the Michigan State Police Marijuana Tobacco Investigation Section. Robert Hendricks is the chairperson of the State Bar of Michigan. Dale Hilson, Prosecuting Attorneys Association of Michigan, also known as PAM. Barton Morris, attorney at law. John Palace, Assistant Attorney General. John Sachs. Yeah. Adam Sandover, and of course Ken Stecker, Prosecuting Attorney Traffic Safety.
Pam.
So
Pam gets two people on the board?
But it seemed like they got a diverse group. Michigan Attorney General has convened a work group, and they want to look into potential change. So this is now a publication in August. So since May, June, July, August, 3 months, they put a bunch of time in here.
Yeah.
Put those brains together.
Yeah, it's important.
And said the following. The law, which was approved by voters last year for persons 21 years or older, and established a framework for taxation regulation of marijuana business. But according to the Attorney General, who supported the proposal in 2018 ballot, there are still questions about how to implement the law, such as the issues of what penalties to impose for marijuana-related infractions.
$100 ticket.
That's what I would think, Jim. I would think that would be the answer too. So now this is quoting. So now there are certain portions of the bill that something's illegal, right? But then it doesn't tell you what the penalty is.
$100 ticket.
One such example is the public consumption of marijuana, which, as with alcohol, is prohibited. But according to Livonia City Attorney Paul Bernier, it remains unclear how it will be dealt with in the law.
$100 ticket.
We tell people that they can't consume it in public, so they're sitting in Hart Plaza smoking weed. Is it a possession of marijuana, a one-year misdemeanor, or is it a use of marijuana, a 9-day misdemeanor?
Or is it a $100 ticket, a civil infraction for a violation of MRTMA?
This could mean the difference between having an infraction that shows up on an individual's criminal record and whether their employment, housing, or protects. Oh, really? You mean that the whole idea of whether we're going to legalize marijuana in Michigan is going to impact whether an individual's criminal record, which can affect their employment, housing, right? So he's not sure after MRTMA passed if the intent of passing MRTMA was to, and he is in this organization that's headed up by Dana Nessel. He's a spokesperson for it. Another ambiguity concerning growing marijuana plants. The law does not permit home cultivation, quote unquote, visible from a public place. But it's unclear whether an individual who does so would be charged with a 1-year misdemeanor or
$100 ticket.
a 4-year felony for manufacturing.
$100 ticket.
We don't want people guessing what is illegal or legal. What the penalties are. My concern is it's not clear. The legal marijuana work group convened by Attorney General also includes police officers, defense attorneys, really, prosecutors and regulators. They aim to clarify. Let's name who are the defense lawyers on that would let such a tragedy of an interpretation take place. Let's name them. We got Daniel Groh. Robert Hendricks is not that, but Barton Morris. I don't know who else. Who
Dan
else?
Groh and Robert Hendricks were on the drafting board.
Do you remember talking about that? This would be felonies, possibly.
No, they know.
What was it supposed to be?
Civil infraction,
Okay.
$100
Since
ticket.
you're- I don't hear-
$100 ticket.
Nowhere in here do I hear.
Fuck Bill Schuette.
Fuck Bill Schuette.
The aim is to clarify the ambiguities. The work group is already bearing fruit with Nessel.
What?
Rotten fruit, stating that her office is in the process of drafting new bills. They want to get new bills.
Oh, there it is.
Okay,
there you go.
Josh Hovey, here we go.
Oh,
here we go, our
God.
spokesperson. Cannabis Industries Association. I don't even know what that. It said the organization is familiar with the work group and is wary of potential wholesale changes. From our standpoint, in general, we believe the law should be implemented as it is.
Yeah.
However, if there are changes needed for clarification, or minor wording changes, we wouldn't necessarily be opposed to those. Yes, we would.
Of course we would.
Who is
Leave it
he speaking
alone.
of? But
Leave
we
it
would need to
alone.
teach. We need to each
Hope they
proposal
clarify
change, look
the
at it for its own merits. Even if the work groups comes to consensus on certain legal issues, there's little guarantee that a subsequent bill or amendment would make it past the legislature. Instead of simple majority, citizen-initiated law required 3/4 vote, and lawmakers to approve any changes. And I think there's a getting 3/4 of the legislature to agree on anything is virtually impossible, Nessel said. So maybe this is a fluff. There are things that we all agree upon, but we don't know how we're going to be able to necessarily move forward on it. It's going to be interesting. I mean, we're going to try, right? So Nessel, but am I wrong to think that by saying that there's ambiguities when there's not, it creates ambiguities? And now for the first time ever, there's someone out there that thinks that an arrest would be justified for and charging someone with manufacturing marijuana. And what happens after this? What about the gifting? But you give someone a kiss after the gift, and they count that as remuneration, and they take you out because you're not allowed to.
Depends on if you get engorged or not.
Yeah, that's always a problem.
That's a good point.
You know what? I heard they have a recognition evaluator now to determine that. Just kidding.
It's the wrong show, Jamie.
That would be an engorgement recognition evaluator to see. That's funny because that's like the DRE, the driving. Don't call them an expert. They're evaluators. All right, so I was troubled by this. I was troubled that, it's, if I may just point this out, the interpretation that was proffered from the MMA was that it didn't legalize marijuana in Michigan. It created a limited exemption for people that were in strict compliance with the law for behavior that would otherwise be illegal. And if you were outside of the strict compliance part, according to the police, they pulled you out of the protections and you were subject to all this other, you defaulted into the public health code. Now, this is absurd. And the idea that the police get to decide this is also absurd. They are not the ones in charge of regulating what was the Department of Community Health, but they took over the reins and moved to the law, and all of a sudden the police are the ones that are deciding immunity without any process or anything. It's absurd. But that was the justification. Didn't legalize marijuana. Here, you have the same people that proffered that interpretation that really, and the impact of that interpretation was that, they don't have to try to find out, or do they care if you're a caregiver or patient. The state authorizes the growing of marijuana.
You're going to jail.
PC to get into the house is all the stuff that the government authorized you to do. But anyways, the idea that the interpretation here would sadistically fall into the public health code when one was outside of it.
Of course it was. We knew it was. We did. We knew.
You knew what?
We knew that this was going to happen.
Well, I'm saying to you that the justification of it is based on the premise that the MMA did not legalize marijuana. It created a limited exemption
Yeah.
for persons.
And
who
they're
met the
saying
strict- and now they're saying that the MRTMA didn't legalize marijuana. Yes, it did. The law says the intent of this law is to legalize marijuana for
Yep.
adults over the age of 21.
I agree.
The last paragraph says this law is to be interpreted broadly. Any conflicts, this law prevails, and it's to be enforced like the paragraph that I just read, which is that this law is intended to legalize marijuana for adults 20 and over and regulate. Blah,
freeze
blah, blah.
the weed. Yep.
So I'm saying to you,
How's that
this
working
is
out?
like blasphemy. This is, I mean, I'm saying.
Well, yeah, that's why I
in the
asked you why
context-
she's doing this. Why is she doing this? I don't understand.
It does not seem. I mean, first of all, she said she read the law.
I don't think maybe she read a different version than I did. I'm not sure how that would have been possible.
I'm surprised. I am surprised that that such a discussion would ever take place. It seems like they're looking for ways to criminalize marijuana despite the law being otherwise. But
That's exactly what it looks like. It's $100 civil infraction. Let me tell everybody, $100. There's limited exceptions to when it might be a little bit more of a kick in the ass if you are habitual,
Sales to
willful,
minors.
commercial
Depending what the
purpose.
activity was. But the intention in the room was it should be
$100.
something that creates a scenario where it will not always necessarily be the priority of police to worry about an investigation that might lead to a $100 civil infraction ticket as opposed to other things.
at the end of the day, none of this would matter. There would be no interpretation that could be other if they take it off the schedule.
Yes.
Okay, see what I'm saying? So the combination
Well, no,
of
they don't just have to take it off the schedule because they have
They have to
now
unschedule it.
littered the public health code with crimes specific to marijuana.
I know. So if it's off the public health code, they got to write a bunch
They
of
got
new
to get
stuff.
it out.
They got
Gone.
I was going to say if there was a criticism of MRTMA, it would have been that it should have been some language removed from the public health code,
Yeah.
right? It didn't. But
that was suggested by a couple of us.
Us.
It didn't happen.
The problem is
it's too. I know whatever the excuse is. I'm saying to you that
Yeah,
the
there's lots
John
of
Sinclair case, like belly buttons, everybody's got one. Like the
Yeah.
John Sinclair case could right the wrong, and I'd like to believe that
It could
the
help.
Attorney General,
It could help.
I mean, the confusion.
I don't know why she's
I
fighting.
was saying the confusion. If there's confusion, I would argue the unscheduling.
Why isn't she here asking us? I don't understand. I'm
Do
really.
you guys get emails from MI Dems?
Yeah, of
I don't.
course.
You know why? Because I told them do not contact me anymore. I'm off their list.
Well, you
It's a
should.
little annoying. They sell you. They sell their stuff, right? Oh, I'm sorry. You're not there with me yet.
I'm not Chad. I'll remind you again.
She's not Chad.
Okay.
How did that get resurrected? Did I?
Well, you were,
Am I up on the- I'm just
hurling Democrat insults at me.
Oh.
So.
I wasn't. I thought I offended you.
Wait, what? No. But
No, I was saying, I
you're
thought-
making intense eye contact and
I
screaming
thought
about.
you were going to defend that.
No, I
Yeah.
was not. I am just as angry and put out as you are about this, if not more.
It's
So there's just since there's a slight breakdown in the conversation here for a moment, there should be time set aside for a celebration for Amanda. Just wondering.
Well, yeah, let's start doing that.
Yeah.
I wanted to talk about this stuff anyways. This other stuff. Okay.
Yeah, he has
Take
to
a
get
2-minute
resolved.
break. Regroup.
No, hold on.
We have
No,
to.
yeah.
No, wait. Jim was lax in his duties, but it will only be momentarily. I promise. Keep talking, Michael.
Keep going. Keep going. You're fine.
I don't know. We.
Yeah, you want a tirade about Democrat?
No,
Go
I'm
ahead.
done. I don't even. I just not either or. I'm just.
You know what's coming up
not
next?
At me, just not at me.
Mark my words. You know what's coming up next? Driving. And let me tell you what a sweet shit show that is going to be.
Yeah.
Because once they come, and it's going to happen. It's going to happen. And then people are going to start going to jail. And that's going to suck.
What do you mean?
I mean that they
But people are
going
to start driving with,
they're gonna
cannabis in their system, Jim? Shocking.
No, it's not that. I mean, they've always been driving
That's
with
what.
cannabis
Yeah.
in their
So what are you
system.
talking about?
I'm saying
they're
that
gonna start
the
to pull-
police are
pulling
going to
people
start
over.
pulling people out of the car,
They're going to do sobriety checks.
and they're going to arrest them, and then they're going to draw your blood, and if there's any
I thought
cannabis,
those were illegal, sobriety lane checks and things like that.
it's. I mean, it's not illegal to pull you over for a broken taillight and say you smell weed in the car.
And be mistaken about it.
Right. It's a reasonable mistake.
Let's talk
Good,
about
Jim.
something happy.
Cannabis is very
Just
pungent.
picking up on the key.
It's very pungent.
I have good news.
Well, let's hear it.
Yeah. Ecuador legalized hemp.
That is big
Alright,
news.
that's
That is
big news.
Wow.
That's big news.
Nice.
Yeah, way to go.
That's a
We should
farm-
all
that's
take a trip down to
farm,
Ecuador to
country.
celebrate
Let's go.
in mass.
Let's go.
Let's do it.
That include the Galapagos?
Yes.
Sure.
Anything in the region, we're going to visit it all.
No, there's the
Ecuador is the Galapagos, yes.
All right.
right there. Certified.
Well,
All right.
But there's lots.